Greetings, everybody. This is Professor Hussein again. Chapter 7, Exculpatory Contracts. Very brief contracts, very brief presentation with regards to certain aspects of aviation as well. Uh, although although exculpatory contracts are rarely used risk management tools inappropriate in most aviation operations, they can be extremely important for those who involve such high risk as to be uninsurable. You should be aware of availability of risk management tools and know its use is appropriate. Purpose of this chapter are like number one, to ensure that you recognize those unique circumstances where exculpatory contracts may be appropriate to limit potential liability, to ensure that you appreciate the value of utilizing services with legal counsel as in preventing lawyering in the role drafting or other legal documentations. Exculpatory contract is an agreement between aircraft or airport operator or participant in aviation operation by which participants agree not to sue the operator of aircraft or airport if participant is killed or injured during the operation. These contracts can range in complexity from multi-page contracts typically signed by today by sports skydivers uh, often after viewing a video briefing by skydivers center lawyers on serious legal importance of documents to the fine prints on the back of spectators' airshow admission tickets. So when we talk about airshow admission tickets, we understand skydiving, but airport airshow admission tickets, that means that if if you are a spectator and there's a crash and somebody gets killed, that's liability is not on the airshow operators. So we have to be looking at that as well. Today, in exculpatory contracts, generally appropriate risk management tool only where the operation is not common carrier operator, such as carrying passengers for hire and authority of Part 135 or 121 Air Carrier Operating Certificate. The activity or relationship is not the one in which law requires operators to carry liability insurance. Federal Act of 1958 requires air carriers to maintain certain levels of liability insurance. And state law requires employers to provide workers compensation insurance for their employees. And insurance, and in number three, insurance, although not required by law, is not available to these operators. Exculpatory contracts are generally used in operations that are perceived by conservative insurance companies as being out on the ragged edge, involving high risk for which no actuarial statistics are available to the insurance company, constituting unknown risk. This has been long included airlifting, skydivers, or bungee jumpers, or motion picture stunt flying, as well as one of those James Bond shot before computer generated imagery where stunt pilot doubling for Agent 007 flies a tiny experimental BDS-5 microjet through a hangar where hangar doors are closed, barely squeaking through 90 degrees bank angle. So you can see the risk involved in this type of things where the insurance companies are not willing to take that risk. That's the essence of the whole thing. Uh, this is it for chapter 7, and I shall continue with chapter 8 in the next lecture as well. Thank you. Have a great day.